welcome to all our visitors. Call the meeting to order. Patty, would you please call the roll?
Lynn Batten, Al Eckert.
Here.
Richard McMullen.
Here.
Thomas McWilliams.
Here.
Rusty Moss.
Here.
Charlie Speights.
Here.
Matt Ford.
Here.
We have a quorum.
Thank you, Patty. Next on the agenda is the approval of the February 27th commission meeting minutes. Commissioners, does anyone have any additions or amendments to the minutes? If not, I'd appreciate a motion to adopt minutes as written. Motion by Commissioner McWilliams.
I'll second.
Second, McMullen, all in favor? Thank you. All right. Next is Chief Administrative Report. Stan, good morning.
Morning, Commissioners. Welcome, Commissioner Ford. We have, as we talked about last month, an update for the town of Tawnytown, the city of Tawnytown. So in October of last year, I provided an update on the sampling, the air sampling study that occurred in May 2025. And so just to provide you an update on where we are, I would first like to start with a little bit of background because we have some newer commissioners. And so just a brief history to kind of get us up to speed before I provide the update. So the city of Tawnytown has expressed some air quality concerns, and in December of 2023, in response to that, we requested support from the Army National Guard 61st Civil Support Team, and they conducted overnight air monitoring tests using a multi-gas monitor, and that detected the potential presence of sulfur dioxide. After that 24 hours, they recommended an additional 5 days of testing. And so with that recommendation, we requested that they deploy again for 5 days of monitoring, again using the real-time multi-gas monitors. We also engaged an experienced and independent environmental contractor, CTEH. They have the capability to conduct more sensitive analytical sampling, which collects the air over a media and then is sent off to a laboratory to analyze. This gives you much lower detection limits, much more sensitive than those real-time multi-gas monitors. Their detection limit is 0.1 ppm. The detection limits for this analytical media gets down into the ppb range. And so we wanted to make sure that if it was present, we were able to detect it. So that was conducted for 5 days. And when we received those results, that was in February of 2024. And we received those results in February 12th, 2024, and then again on February 26th, 2024. Sulfur dioxide was initially indicated in both the December 2023 and the February 2024 real-time tests conducted by the 61st. However, it's not detected in the analytical samples detected by CTEH, nor their 120 multi-gas monitor readings in the same area. So at the conclusion of the experts, based on the data presented by the experts, we concluded that there were no human health or environmental concerns for SO2 or H2S during that testing period. So then, however, the CTEH analytical report did detect the presence of 2 volatile organic compounds, benzene and acrolein, and those were detected above regional screening levels for residential air. And now it can originate from various sources, but with them being over regional screening levels, we wanted to investigate further. A regional screening level, that's what it's designed to do. So if you exceed it, then you are, supposed to investigate further. There's been some confusion on residential screening levels versus U.S. background levels, and in which cases we compared the results to either or. So a residential screening level or residential regional screening level developed by EPA, it's designed to be protective for 26 years, 24/7, 350 days a year. I guess they assume you're going to go on vacation a couple of days now and then, but So it's very sensitive, very low conservative threshold, rightfully so. And so exceeding that limit is not immediately threatening. It's just something that you want to look into further. Now, a U.S. background level is just what is present in rural and suburban areas normally, what air quality, what constituents at what concentrations is normally present in the background in these types of communities. So two different measures and two different ways to compare. This test in February 24 compared against the regional screening levels, and it did exceed those. So therefore, it warranted further investigation. So as a result of that, we coordinated with the Arkansas Department of Health to develop a testing protocol that would help us understand the source of these two chemicals. Again, they can come from a variety of sources, but if we can understand whether it's coming from a point source or not, that's within our wheelhouse to do. So because of the possible harm to human health that these constituents have the ability to impose, we issued emergency procurement to retain the services of CTEH and conduct additional air monitoring. So in April of 2020, we conducted air monitoring for 3 days using the analytical methods again and the real-time multi-gas monitor. This test detected benzene, acrolein, carbon tetrachloride, upwind, crosswind, and downwind from the Ecovista landfill, which is a permitted facility in the town. Additionally, these same chemicals were detected in the 4 background monitors that were probably about 3 miles from the landfill in each cardinal direction. Chloroform was detected in these analytical air samples as well, one at a crosswind location of the landfill, and then naphthalene was detected 1 time in a background location. So we have 5 chemicals now that have been detected, 3 additional to the benzene and acrolein. We requested that ADH analyze these test results, and they came to their own conclusions, and their summary noted that there is a completed pathway for inhalation exposure for the residents in this town that live near the site and further away. However, they noted that the benzene levels were in ranges for expected rural subdivisions. So again, kind of comparing to the background levels. And based on this data, we concluded, along with ADH, that we couldn't determine the source of the contaminants again. So following that analysis, we determined it would be necessary to initiate formal procurement to do through the state procurement office to secure a vendor that can conduct additional sampling and analysis. We coordinated with ADH to develop a protocol that would help us understand the source of these volatile organic compounds. Again, for this next round of sampling, we are trying to determine the source, not necessarily concentrations or chemicals. We kind of have an idea of what's out there and at what levels. Now we are trying to understand the source.
What date was that?
So we received the report in June of 2024. So we started the procurement process then. No, that's fine. The full procurement process ended in April 2025 when the contract was awarded. We had to go through Arkansas Legislative Council, and so that contract became effective in April 1st of 2025. So this study used a dispersing ring pattern sampling location layout to try to understand where the source was. In addition to these fixed locations for the sample containers, we also had the ability for citizens to report, they called a hotline if they had an odor or an air quality concern, and the contractor would go out immediately and take a 1-hour analytical grab sample at that time, and those were analyzed as well. So this was an 11-day study. May 12th, 2025 is when it concluded, and we received the final report September 8th, 2025. And it concluded that no compounds were identified as having contributions most likely from the landfill. 2 compounds, benzene and ethylbenzene, were identified as having contributions likely from the landfill in parts per trillion range. So again, I told you about the ring dispersion pattern that these samples were laid out in. The contractor used statistical analysis to determine if it was downwind fence line and if it was statistically decreasing as you went further out into the community or into the background. And so if it met that factor, it was likely from the landfill. That's how benzene and ethylbenzene were determined to be likely from the landfill. And again, this was in the contribution was in the parts per trillion range. As you go out into the community, you can see it become consistent with background levels at that point in time. So the CTH report details that the concentrations for both benzene and ethylbenzene were higher on weekends when the landfill was not accepting waste from the working phase and was covered compared to weekdays. So the way we confirmed this is we had the landfill report their daily cover every day of this 11-day study. We started once the testing began, and we try not to share the date the testing would begin, but once the cans are out there, it's kind of known. And so we asked them to snap a picture of their cover because they are approved for alternate daily cover. We wanted to see if the cover could be, the type of cover could be contributing to the air quality concerns in the city. And so this statistical analysis just demonstrated to us that the daily cover was not affecting the air quality, as it was better on the weekdays when the alternative daily cover was in place versus on the weekends when the landfill was closed. Of the 50 constituents sampled, 36 were detected, and all detections were within US background ambient air concentrations except for one, acrylonitrile, and it was not detected during any of the previous sampling events. This chemical was identified as having a contribution not likely from the landfill. It's possibly from another source because it consistently had detections higher in background locations than near the facility. So that was their indication that it was not likely from the landfill, that it was coming from another source. The 2 sample locations that exceeded the background levels were at AS18, which is 4 miles south of the landfill, and for the most part of this study, in a crosswind location. That detection was 15 ppb, so significantly higher than US background levels, and also higher than what you would expect for residential screening level. And then also on May 8th, it was detected at AS11, which is 2.5 miles north and consistently upwind of the landfill. So those are part of the reason why it was classified as not likely from the landfill, is because of those two detections. Again, ADH helped and did a public health assessment, and so they used this data from the report, and they analyzed the compounds of concern that were likely or possibly from the landfill, and then also acrylonitrile, since it was the one that exceeded the background levels. Their conclusion was that several compounds were found, but only one, acrylonitrile, was above federal health guidelines. So that is the study, but where we are now, we received on January 7th of this year a letter health consultation from ADH, and it noted that there are no significant health risks associated with contributions from the landfill, but it did note again that acrylonitrile was above federal health concern guidelines regarding both non-cancer and cancer risks. So we shared these findings, both from the health department and the CTH report, with EPA. And we are continuing to research potential point sources for acrylonitrile in this region. And we've also specifically requested assistance from EPA Region 6 Air Toxics Enforcement Section. And there have been communications, but we're not sure what their status is at this time. Additionally, the May 2025 study identified that some odor from the South Penalto lift station. It's owned and operated by the city of Tawnytown, and so there was a potential source of odor there. There were frequently odor detections there and a couple of complaints about odor in that area. So therefore, as a result of the study, on June 13th, we requested the city of Tawnytown perform an evaluation of its collection system in this area. And in August of 2025, the city submitted a sewer evaluation report. That report recommended annual lift station cleaning, replacing the air scrubber media, and remediation of 4 manholes that showed deterioration in the area. And they've kept us updated with their status of their December 25 report. It updated that it had cleaned the collection lines and had operated the air scrubber at the lift station. And the city reported that the manhole rehab is expected to be completed this month. On December 4th, 2025, we received a report from Carbon Chicken. Did not request this, but I think the city, I'm not really sure who commissioned it actually, but they did provide us with a copy of the report. And it was designed to assess the potential emissions originating from the leachate at the lift station. So this lift station only receives leachate from the landfill. I should point that out. So they took an air sample before and after the media was replaced, the air scrubber was replaced, and they provided that. It's unsure what to make of their report. The initial sample was noted to be leaking when it arrived at the lab, and so those detections are lower than after replacing the media. So we're just unsure of how to draw any conclusions with those quality assurance concerns. And then lastly, on January 5th, 2026, we requested that Ecovista provide an analysis of their leachate, and they did submit that to us. They submitted 2 years worth of data, and so that's currently under review of our Office of Water Quality. And that's the update for today based on the 2025 study. Are there any questions?
Thank you. Yes. I guess your follow-up there was mostly dealing with air issues, as I can tell.
And the lift
And the
station.
leach station,
Yes.
I apologize. Also, as you're aware, the commission has received this report, I guess, or letter from this journalist who did an investigation of this. And there's been something published, I understand. I haven't read it yet, but something published in the Arkansas Times about it, dealing with landfill. But they discussed air pollution. They also mentioned water contamination. They also mentioned elevated temperatures in the landfill.
Mm-hmm.
So I would appreciate, for the public benefit, that if you and your staff could come back to us on those issues and tell us what the status is on that.
Yeah.
I just don't want to leave some issue hanging out there that nobody knows exactly what's going on. So
Yeah, absolutely. Their temperatures are reported in their semi-annual reports, and so we can definitely put that together for you.
thank you very much. Before you go, commissioners, anyone have any other questions, comments?
I got one.
Judge Moll?
Thank you, Mr. Chairman. So, Chief, in terms of the entire analysis, I think it needs to be made clear, number one, there's no dispute that landfills smell. They stink. Right? I mean, we can't argue about that. But the fact of the matter is, the division as well as the commission, we don't regulate odors. We don't have a regulation that deals with odor, correct?
Correct. Well, I'm not going to go so far as to say we don't regulate it. Sometimes odor can be indicative of a
problem, but as a practical matter, we don't have a specific threshold level for smell, for odor.
not a quantifiable one.
And then looking at everything, did we ever test for the analyte hydrogen sulfide? Do you know?
We did in
Okay.
February of 2024.
And what do you remember what the results were for that?
Non-detect.
That was my questions and my comment.
Thank you, sir. Anything else? Thank you very much. Next on the public comments, no comment cards today. All right, if anyone wants, this is the public comment period. If anyone wants to speak, we will certainly give them an opportunity to do so. I don't see anyone racing to the microphone, so we will move on. Next on the agenda is this motion to adopt final rulemaking. Mr. McAllister, I believe you're up to bat.
Yes, sir. Good morning, Commissioners. Michael McAllister. I'm an attorney for the department. We're here on a motion to finalize rulemaking. You may recall this rulemaking was initiated back in January to update 18 CAR Section 161304. This is a specific section of what we formerly referred to as Rule 22. Rule 22 is kind of a big rule that deals with lots of solid waste issues. But there was an act in the 2025 legislative session, Act 791, that changed a dollar figure for a specific section of that rule dealing with expenditures from the post-closure trust fund and what amount of expenditure would need to come before this commission for review and approval. That expenditure threshold was changed from $50,000 to $2 million by that act. And because that act changed the law, we have obligations to update the rule in a timely way to reflect that change in law. So we initiated this rulemaking in January, had a published public notice. There was a 30-day comment period for public comment. There was a hearing held, a public hearing held. That hearing was on February 25th. The public comment period ended on March 11th. There was one public comment offered on this rulemaking. I believe the text of that comment and the division's response is in the packet that we provided to you for this morning's hearing. And we would, I believe there's a minute order in front of you to approve this step of the process, so it can go on to legislative committee review. I believe those are in May. You know, fiscal session starts here in another week and a half, and we're hopeful to get in front of the ALC subcommittee and ALC in May to finish this up. And so this change as enacted by the legislature will be reflected in the Code of Arkansas rules. So I would ask for favorable consideration of the minute order, and if you have any questions, I'll be glad to try to answer them.
Thanks, sir. Commissioner, want to have any questions for Mr. McAllister? All right, do we need a motion to adopt this minute order for the final rulemaking? Motion, Commissioner Space, second?
I'll second.
All right. Thank you. We have a motion second. All in favor, say aye. Opposed? Thank you, sir.
Thank you, Commissioner.
All right. Next on the agenda is arguments regarding docket number 25-000P, City of Decatur. Welcome the attorneys. Judge Moulton, would you give everybody the ground rules?
In truth, it's been a while since we've had one of these as chairman. So let me go over the ground rules. Each side gets 15 minutes. Mr. Williams is representing Tulsa in this matter. Mr. Williams, would you like to reserve any of your time for rebuttal, sir?
If acceptable, I would reserve just 3 minutes.
3 minutes, not a problem at all. I will note it. And as soon as I get this clock ready, Mr. Williams, I'll go ahead and turn it over to you. Let me, again, go over the ground rules. I apologize. I skipped ahead. So each party is going to give their presentation. And then after their presentations, we'll turn it over to the commission for questions. Mr. Chairman, usually the typical thing is you just go down the line and ask if any of the commissioners.
I'm gonna let each commissioner, if they have questions, ask.
Right. I will remind the commissioners, you're only limited to asking the attorneys questions or myself questions. It's not an opportunity to go and open up the record and start asking questions of the people that might be assembled here. That would be inappropriate. Again, just a reminder, I know some of you probably have never even participated in an oral argument before, but it's just limited to asking the questions of the lawyers. And at the end of the day, if you think the recommendation is incorrect, you agree with Mr. Williams in terms of his opposition, you have the ability to remand it back to me with instructions or just overturn it entirely. It's up to you at this point what you would like to do. But if you think the recommendation is correct, then you go ahead and have a motion and adopt it. But you do have the ability to modify anything that you would like within the four corners of that document. All right, with that, I'll go ahead and start the time for you, Mr. Williams. Go ahead, sir, the floor is yours.
Williams, welcome to Little Rock.
Thank you, Commissioner, and all the commissioners. I'll try to speak into the microphone. I often receive complaints that people can't hear me because I have a soft speaking voice. As Judge Moulton indicated, Hall Estill has the honor of representing the city of Tulsa and the Tulsa Metropolitan Utility Authority. I'll just refer to them collectively as Tulsa for this discussion. As the commission may know, Tulsa is one of the largest providers of potable water in Northeast Oklahoma. We utilize raw water from the Ucha, Spavinaw watershed. And the concern that Tulsa has is that the watershed will be negatively and dramatically impacted by the city of Decatur's application, which has been before the agency. We submitted comments regarding this back in October of 2025. The Uchi watershed, the Uchi Spavinaw watershed, it's very important to the people of Tulsa, Northeast Oklahoma, and Northwest Arkansas. The issue for Tulsa is water quality. And specifically with regard to Decatur, the issue is Decatur's inability to appropriately treat wastewater, which is discharged into the watershed. So given that this historical lack of compliance, Tulsa has suggested that a large error rate with Decatur's data and the seeming lack of ability to take on more flow without first addressing the lack of existing compliance, Tulsa believes that any expansion in the flow rate will adversely impact water quality by polluting the watershed with additional phosphorus. There are alternatives which could allow for greater flow, but there would need to be substantial compliance improvements. So this is the discussion that Tulsa seeks to have in the permit application process. That's the merits that we had asked to have a hearing, an opportunity to present through expert witness testimony our concerns. However, that has been denied, basically through a procedural issue. So with regard to the issue before you today and the permit, we object to the issuance of the permit. We believe that issuing the permit will be an error because the increase of flow into the plant of 5.36 million gallons per day will result in additional phosphorus into the watershed. We assert that the unlimited flow from the city of Centerton without significant pre-treatment is going to be a problem. The allowance of flow from the Simmons food plant without requirements for significant pre-treatment is going to be a problem. And that there's going to be inadequate monitoring. All of our concerns were outlined in earlier submittal to the agency. So the issue again on the merits is that Tulsa is directly and negatively going to be impacted if this permit is issued as presently proposed. So with regard to why we're here today. The ALJ's recommended decision, which was filed on February 26th of this year, states that Tulsa's original request for hearing regarding Decatur's permit was a nullity because it was not signed by an attorney licensed to practice law in Arkansas state courts. And the ALJ, from our perspective, improperly dismissed our request for hearing on a technicality instead of on the merits that I mentioned a few moments ago. However, it's worth pointing out that the ALJ recognized that Commission's regulations do not contain any provision regarding licensing required for attorneys to request administrative hearing. Let me restate that. There is no provision in the regulations of the agency requiring an attorney to be licensed in Arkansas to request an administrative hearing. The ALJ also admitted that the Commission's regulations do not treat the request for hearing as a complaint that you would have in a lawsuit. Instead, a lawsuit complaint starts a civil action through the court. This request for hearing is only a ministerial act to start the process of appearing before the agency. We never get to that under the ALJ's decision or recommendation. The ALJ recognized that there's no rule, but indicated that silence does not equal acquiescence. From Tulsa's perspective, the ambiguity and silence, no presence of administrative rules means it's designed not to provide due process. And that's a denial of due process itself, because if you don't know the rules, how can you follow them? Tulsa was denied due process on the merits if the ALJ decision is allowed to stand, because the rules governing the commission is existing statutes from the General Assembly, guidance from the Arkansas Supreme Court. None of those are specific and requiring that an attorney who's licensed to practice law in Arkansas be the signatory to a request simply to start the process. This lack of clear rules on this issue, from Tulsa's perspective, results in denial of due process. I want to also point out that the ALJ admits there's no case from Arkansas Supreme Court requiring all executive agencies to establish a pro hoc vici proceeding. I'm going to not assume that you know what that is, but a pro hoc vici is a process whereby in the courts of the state of Arkansas, attorneys from another state may obtain permission to appear before the court. There's no such proceeding available under the rules of this agency. So there's not even a process to follow to do that. The only guidance we have is from a decision that the Arkansas Supreme Court made back in 1973 that states that the unauthorized practice, at least by court appearance, is an unlawful intrusion and usurpation of the function of the officer of the court, constitutes contempt of the court. That's the distinction that should be made here. Appearing in front of this commission, it does have some aspects of practicing law, and we take no issue with requiring an attorney, which I am licensed to practice in the state of Arkansas, to appear before you. What we take issue with is just to ask for the opportunity to have a hearing. It's not the same. So that's one of the basic issues that we bring to your attention. It's also worth stating that one of your sister agencies, the Arkansas Public Service Commission, specifically allowed out-of-state attorneys to appear before it. There's a specific rule for it. 4.01B of the Public Service Commission that allows out-of-state attorneys to appear. So the ALJ's decision could be interpreted to indicate that the sister agency's rule allowing that is unlawful and that it supports the unlicensed practice law. We respectfully disagree. It is undisputed, I think, and Judge, I didn't quite catch when we started, how much time do I have?
I'm sorry, Mr. Williams, you get about you're at 9 minutes, so you get about 6 minutes left.
Thank you, sir. It is undisputed that Tulsa is entitled to due process as a matter of both federal and Arkansas law. This agency and every agency adopt rules and publish them, just as you did a moment ago. You had a situation where a new rule came before you. And the whole purpose of the public comment, or the whole purpose of the rule, is to provide guidance for people who want to appear before you or bring matters to your attention so they know what rules to follow. So those rules provide a meaningful opportunity to be heard and to avoid arbitrary and capricious decisions. If the rules as being applied here by DEQ are allowed to stand, or this dismissal is allowed to stand, you're ruling on the basis of an unpublished decision without any kind of support from an Arkansas court. Absence of clear authority as to how and what's required to appear before or to ask to be before the agency, it's just at its very most basic unfair. And the absence of clear guidance or any published rule by the agency should be the basis for some, and we suggest it's good cause for there have been additional time allowed for this request to have been allowed. Again, the ALJ has essentially determined that a request for a hearing before the agency is the very same thing as a new lawsuit in front of an Arkansas circuit court. Again, we respectfully disagree. A request for a hearing is just an administrative, informal document which starts the process for an objector to obtain review by the commission. There's only 30 days from the date that a decision is made within which an objector to ask for a hearing. It's a very short time period. It's not the same as a judicial proceeding where there's a statute of limitations that allows some period of time for someone to bring an action to oppose a position. And so there ought to be some grace granted in this type of a situation because it's a very short period of time, good cause to give some grace. Grace has not been extended to Tulsa at this point. So we suggest respectfully that the ALJ's position supporting its recommended decision is based on a false premise that a request for a hearing is the same as a lawsuit. It just simply isn't. There's no support for it in administrative rules of the agency. There's no decision by an Arkansas court that supports it. It's clearly, from Tulsa's perspective, a denial of our right to due process. We are entitled to a hearing on the merits. We submitted our request for a hearing. I signed the amended request the day after we heard about this. And we respectfully suggest that there's good cause to extend a little bit of time, a little grace to Tulsa so that we can have a hearing on the merits and not be dismissed on a technical, unsubstantiated determination. And I reserve the balance of my time, sir.
Not much. I'll still give you the 3 minutes.
Thank you.
Mr. Williams, that's fine. I did interrupt you a couple of times as well.
Want to let the commissioners now if they have any questions for you.
At this time?
Yes, sir.
Great.
Yes, sir. Mr. Ford, any questions?
Well, hey, Mr. Chairman, why don't we go and listen? I mean, typically we listen to the rebuttal to this argument
Do it that way.
and then we ask questions afterwards, if that's okay. I'm sure you're going to have them. Yeah. All right. I'm sorry.
Get back. That's your-
Yep, I'm sorry, Mr. Williams, don't mean to cut you off. Like I said, it's been a while since we've done one of these. Mr. Hicks, you're up. Let me reset the clock here. All right, floor is yours, Mr. Hicks. Go ahead.
Thank you, commissioners. I'll try to be brief. I do want to touch on a couple of points. First, the administrative law judge's recommended decision addresses the issues that Tulsa has raised here today. It specifically the unauthorized practice of law, the due process, and the good cause. On each point, the administrative law judge found Tulsa's arguments unpersuasive. Tulsa is asking this commission to excuse the unauthorized practice of law. DEQ asked that this commission decline to do that and approve the recommended decision. I do want to specifically address the issue about ministerial as a description of a request for hearing before the commission. This commission has rules that say you have to provide a detailed explanation of the legal and factual basis for the appeal when you present it to the commission. That in and of itself takes legal reasoning, legal skill. That is exactly what Judge Moulton said that this pleading was supposed to do and demonstrated. This is the practice of law. The question is not whether or not Tulsa's attorneys are licensed to practice in a state court of Arkansas. The practice of law is in the state, period. It is not just before the courts. The Supreme Court in Udem versus Board of Law Examiners, as Judge Moulton cited, said that the practice of law includes the things outside of courts. That is exactly what this is. But it is the practice of law. That's what Judge Moulton found. So this is not an issue where it's a ministerial act. Black's Law Dictionary defines ministerial essentially as something that is so clear and obvious that there's no discretion. You're just following the instructions and filling out a form. That's not what this is. You have to describe the legal and factual basis, the legal reasoning and the factual support for why this decision is not in accordance with this commission's rules in Arkansas law and the federal NPDES program. The other thing, the commission rule 60, formerly Rule 8 car 11602 now, I believe, states that corporations must be represented by an attorney. That is a published specific rule. It is true, it doesn't say attorney licensed in Arkansas, but neither do the rules of civil procedure. The rules of civil procedure for Arkansas also use the word attorney. They don't say attorney licensed in Arkansas, but everybody is on notice that the word attorney in the rules of civil procedure means an attorney licensed in Arkansas. This is a rule of an executive branch of the state of Arkansas. The rules for the practice of law are governed by the Supreme Court of Arkansas. That's their authority under the Arkansas Constitution. And this commission is bound to follow those. So when this commission uses the word attorney, as the administrative law judge said, that means an attorney licensed in Arkansas. Also, the recommended decision addressed good cause and said, there is no good cause that gets around something that is a legal nullity. There's not a good cause exception that excuses a legal nullity. As for the 30 days, I understand that they made that argument that they are asking for grace on that. It's obvious that this law firm has attorneys who are licensed to practice in Arkansas. They did not have those attorneys sign it until after they realized that they had not done that. Again, that doesn't bring up good cause. The time frame doesn't necessarily change the fact that it's a legal nullity. That is just simply what we have here. So without anything further, I'll leave it there.
All right, thank you, Mr. Hicks. Mr. Williams?
appreciate the opportunity to be here before you today and to have this conversation. There's a concept in litigation called trial by surprise. And it's basically a strategy to hide evidence or hide arguments from the other side until the trial is too late to do anything about it. I would respectfully suggest that Paul Estill and Brian Allen, one of my partners, submitted initial comments to the agency on October 13, 2025, long before the request for hearing that we're discussing today. In response to Mr. Nallen's letter to this agency, setting forth the same kind of merit-based arguments that we're making or want to make in a formal proceeding, the agency did not respond saying, oh, by the way, Mr. Nallen, you need to be a licensed Arkansas attorney to even submit anything. I would respectfully suggest that if the ALJ's decision is carried to its logical conclusion, that any contact by an attorney on behalf of a party needs to be an attorney who's licensed in Arkansas. That's simply not the case. The very decision that the ALJ pointed out in his recommendation about an attorney or another case that he heard where there was licensed Arkansas attorneys appearing for the parties there, the ALJ is incorrect. There's no evidence in that record that all the attorneys who were involved were licensed in Arkansas. So we would suggest it's arbitrary and capricious. It's trial by surprise to not have a rule and then impose a penalty for not following a rule that doesn't exist. That's our suggestion to the commission, that you not allow this unfair, inequitable denial of due process to Tulsa on this really important issue based on a technicality that was not brought to our attention until too late, apparently in the ALJ's opinion, to do anything about it. We respectfully request that you reverse the decision and allow us to have a formal opportunity to be heard on the merits. Thank you. And I stand ready for any questions you might have. Don't know that.
Thank you, Mr. Williams.
I'll try.
Mr. Chairman, why don't you stay in there, sir, because I know that they'll get some questions for you. Mr. Chairman, now you can go around the room, and commissioners, if you'd like to speak to either lawyer, you just call them up and they'll take turns. So whoever you have questions for, just because Mr. Hicks isn't at the podium doesn't mean that you can't call him up. All right, go ahead, Mr. Chairman. Over to you.
Commissioner Ford, do you have any questions for either council? All right. Commissioner McMullen, you have any questions? Commissioner McWilliams? All right. Commissioner Moss, do you have any questions? Richard Spades? No questions? All right. My question, sir, I didn't want to leave you with nothing to talk about.
My feelings were not.
As Judge Moulton said in his recommended decision, he referred to, that the State Board of Law Examiners, under the authority of the Arkansas Supreme Court, has determined that representation of clients in legal proceedings in Arkansas requires an Arkansas law license or the Pro Hoc admission. And I'm trying to understand how you're trying to differentiate that from, what has transpired.
I appreciate that question. This is my 49th year of practice. I've appeared in depositions and proceedings all over the country. And the standard in every state in which I've practiced has been appearance before the tribunal is the requirement for licensure in the state where the activity is going on. Whenever we submitted on behalf of our client the request for a hearing, we were not appearing before a tribunal. We were merely reserving space or asking for an opportunity to appear before the tribunal. So that's the distinction that everywhere I've practiced has been applied. And the Arkansas Supreme Court, again, if it's sincere about everything that's done, even outside of a judicial proceeding, must be done by an attorney that's licensed in the state of Arkansas. It would strike down the rule of your sister agency, which is specifically allowing what Judge Moulton is suggesting should not be allowed. So from our perspective, at a minimum, this is an arbitrary and capricious act to, for the first time, very first time that we can tell, an agency is denying an opportunity to be heard on the merits on a technical issue that has not been addressed.
Thank you, sir.
Thank you, commissioners.
At this time, we have before us, as Judge Moulton has already discussed, we have 2 minute orders for us. One from the department, one from the city of Tulsa. Also, if any commissioner has a third order or wishes to amend either of these 2 orders, they can certainly do so. But at this time, if there are no further questions, I would entertain a motion to adopt whichever order you choose before us. If you agree with Judge Moulton's recommended decision, then we need a motion to adopt his minute order, or if you wish to adopt the other minute order, we can certainly have a motion and a second for that, or we can make it, or we can amend an order. So any commissioner wish to make a motion at this time?
I'd like to make a motion to adopt and affirm without modification Judge Moulton's recommendation.
All right, is there a second? Second by Commissioner Moss. All right, we have a motion second. Is there any discussion from any commissioners on these motions? All right, at this time, all those in favor of adoption of the minute order submitted by DEQ adopting Judge Moulton's recommended decision, please say aye. Aye. Any opposed, say no. Decisions made, we adopt that minute order. That concludes our agenda today. If there's no further business, we are adjourned. Thank you for coming.
Mr. Chairman, just make certain that those minute orders are circulated down both for the rule adoption as well as the recommended decision. And we'll go ahead and go off the record.